Hi, Bill Chatt with the Cervantes Chat and Prince Legal Minute for Thursday, May 21st, 2020. Um, have an interesting piece of proposed legislation that I want to talk to you about. I don't know if you out there in TV land have had a chance to see this. I'm using the term interesting in quotes. I'm going to get it up right away. It is the COVID-19 Emergency and Economic Recovery and Renter Homeowner Protection Act. It is a comprehensive act that is going to affect three groups. It's going to affect um, landlords, both commercial and residential. It's going to affect lenders, in other words, banks, and it's going to affect associations, both condo and common interest. It's only proposed. I believe there's a hearing today. From what I've heard, the intention is to get this passed prior to June 1st when the next batch of payments, or a great majority of them, both rent and mortgage, are coming due. So without further ado, I'm going to get this up on the screen. Oh, it's up on the screen now. So there is the name of the act. It's 27 pages. I've highlighted some of the more important aspects of it. And let's go through it. So right here is just the preamble. This is why they're doing it. This is the conditions that they believe make it necessary. You'll recall that we're currently in a moratorium. We can't send notices. We can't send demands. We can't file evictions. The sheriffs aren't serving existing orders of possession. Obviously, they're taking this housing issue quite seriously. And this legislation would expand upon a lot of what we are already under. So the effective date and the sunset. So the effective date, and there's two things to pay attention to. One is what there basically is going to be your COVID hardship period. So it dates backwards to March 9th, 2020, when the governor had issued the first proclamation, the shelter in place. What's a little distressing and confusing about this paragraph, if you look here, my notes might pop up as I was noting things. It's open-ended because the period that we'll be looking at as to whether or not someone would be eligible for COVID relief would go until the unemployment rate is no more than 1.5 percentage points higher than the state unemployment rate for February of 2020, and the published statewide unemployment rate has increased in 2 of the 3 previous months. So what that's saying is, when will this end? When unemployment trends downward to the point where it's only 1.5% or less in relation to February of 2020, and you've had 2 out of 3 months leading up to that where there's a downward trend. We had, I believe in Illinois, a higher than the average nationwide unemployment rate, but it was still decent. And unemployment was in a really good spot prior to this pandemic. So as to when we would get to that number, that really remains to be seen. So it leaves it open-ended. And so down here, you've got the definition of COVID-related hardship: negative financial, medical, or other impact because of COVID. So if you lost your job, if your hours were greatly cut, if you were sick and you were hospitalized, you're going to be typically the person that would be getting relief under this act. Here's some definitions: what a dwelling unit is. I think we all know what that is: a home or an apartment, a condo. An eviction. So they kind of cover this. And so what they're doing here is they are going to upend the Eviction Act. They are going to put all sorts of things that we normally aren't dealing with, provisions, procedures. These are things that are not in the act now. The definitions, again, these are very COVID related. Here's one to pay attention to, because commercial landlords, small businesses, as defined right in here, where the income per employee is 50,000 or less, 25 or less employees, there's going to be relief for small businesses. So if you're a commercial landlord and maybe you've got a strip mall, you occupy one, you've got a couple people in there, you may be subject to the provisions of this act. So here, let's get to the meat of it: residential rent and mortgage cancellation and relief. Cancellation, yes. So if this act goes through, subject to an appropriations and furtherance of Section C, there is hereby declared a cancellation of rental debt accrued for anyone who has experienced this COVID crisis. So this is cancellation. This is not put at the end of the lease. This is not pay a couple of extra dollars per month. It is canceled. And you won't be able to fine, you won't be able to collect, you won't be able to report, it's gone. Mortgage payments. Again, the obligation of a mortgagor, the borrower, would be canceled as well during this time. So that's going to be interesting for lenders. As I said, there's 3 people affected. There's going to be landlords, both commercial and residential, lenders, and associations. Let's focus for a second for lenders. This this it has a bit of an association angle too. This is going to affect lending because if right now you're a lender and you're going through underwriting and you're trying to decide whether or not to make a loan, knowing that the next day, the next week, next month, the loan you just wrote, they could say, hey, I'm sorry, I had some COVID related hardship. They're going to get cancellation. It's a blanket provision. So your mitigation of risk is going to be taken away if this act goes through as written from what I see, because you are going to have to cancel that portion. And again, being that it's open-ended, I don't know how a lender can provide assurance on the risk side that they can do what they normally would do, which is, foreclosure typically. There's some more provisions for lenders here, later in the bill here. But again, this is a cancellation. There's nothing you can do about it. Now, it does say provided that funds come through. From what I understand, the funds are supposed to come through the CARES Act. I don't know where that is. If the funds do not come to the state, does that mean that this doesn't go through because it's a contingent provision? I don't know. It's in committee this morning. We'll see what happens. But again, their goal, from my understanding, is to get this pushed through by June 1st. So again, right here, you can see if a landlord violates any requirement trying to recapture rent, it's going to be a violation. So they're serious. This money will be gone forever. There's going to be a moratorium on foreclosures. Again, if you're a lender, you have to be concerned when your remedy to get the collateral that this loan is secured by goes away. I just don't know how lenders are going to take this and continue to loan money. Okay, for our association listeners here, this here, again, can't impose fines or charges, can't record a lien, which again, if you wouldn't be able to evict, a lot of associations will record the lien to make sure it shows up in title. You have a statutory lien. They're supposed to be asking for a paid assessment letter, but I've been doing this long enough. Somehow these sometimes slip through. So a lot of associations will choose to record the lien. That way it's definitely picked up on title. Won't be able to do it. Won't be able to evict a homeowner or residential tenant for COVID-19 related hardship. So the forcible detainer route that we usually use when people don't pay the assessments after the 30-day demand, you won't be able to do it. And for the association as landlord, for those units that they are renting, where they already got orders of possession, won't be able to evict. What's very noteworthy about the fact that associations too won't be able to do evictions is associations are not provided for in that fund. So it's going to go to landlords. It's not going to be an association option to put in for money lost. I don't, and again, the EIDL loans that it seemed like early in March that associations might be able to get, that's not up and running again. Now, going back to what I said about lenders, if lenders know that they don't have remedies, and then they know that association clients don't have the remedies to enforce their assessment obligations, that might dry up as well. So I really don't know if this ends up being the final version, what's going to happen. It seems to me it's going to seize up the lending market in Illinois, but we'll see. Homeowner protections. There's going to be a forbearance for interest in principal, taxes, insurance. The reason I got this highlighted over here is this pertains more towards the mortgage foreclosure aspect of this legislation. So there would have to be a forbearance period that lenders put through, and it grants a 180-day forbearance period for principal, interest, taxes, insurance, and association fees. Now, what this is doing is, to me, in my mind, is it's incorrectly assuming that part of escrowed items for borrowers would be assessments in a condo or a common interest association. That's not the case typically in Illinois. You are responsible for your assessments outside of your escrowed items. So the only things that are typically escrowed in residential mortgages in Illinois are taxes and insurance. Yet it's saying that there would be a forbearance for association fees. So I would think then, as written, someone could rely on that paragraph to say, look, an association has to do an 180-day forbearance. Again, maybe the final version would be different if passed. And then so there's some more foreclosure rules that are going through. This is the this is going to be the moratorium on evictions. So small businesses, residential, we define what the small businesses were up in the top part of this piece of legislation. You won't be able to evict. You will not be able to send a notice. Any notice that would be sent 5, 10, or 30 days is invalid on its face. Courts cannot even accept a filing. Again, they're going to carve out that exception where there might be a life safety issue, danger to the other occupants, owners, whatever like that. But the standard for non-payment won't even be able to get it into court, which is obviously not our understanding as of today. Our understanding was when the moratorium that the governor had put through expires, we'd be able to resume. If this goes through, that is not the case. The sheriff will not be able to even serve orders of possession to the extent they were to squeak through. The existing ones right now they're not doing, so the sheriff won't do it. And of course, in Cook County, we face different moratoriums as it is, weather-related, the holidays. So I don't even know if the sheriff would unilaterally try something on his own if this didn't go through. But here, sheriffs, which usually in the Collier County we don't have that issue, they would be prohibited from doing anything. So again, here you have, it says there's your exception for protecting the other owners or occupants. The residential, so this is the small business thing. You would not be able to, if you're a commercial landlord, evict either. So that's kind of problematic as well. If you come to an agreement with a tenant, that would be okay. I just don't know how much that's going to happen, given all these protections that are here. The bill goes through some other things. So there's going to be all these new notices that when the moratorium does end, and evictions do resume, which would be a very long time, there's going to be all sorts of new notices that have to go through. There is also some mediation that they want built into this. It gives some new affirmative defenses. It is going to provide for a much larger scale sealing. Right now, sealing is really not something that's supposed to happen, except for in the instance when the eviction really shouldn't have been filed in the first place, or when a defendant prevails. Now it's going to give wide-scale sealing of the record, so you won't be able to, years from now, see that someone ended up getting evicted. That's pretty much a summary. Again, this is 27 pages. The other thing I wanted to pop up here for a second, I just want you to see this is the, where do I have it? This is the legislative link to the bill, so you can kind of keep track of it. I will also put this up on the ccpchicago.com website. So if you go to ccpchicago.com, go to webinar archives, you'll be able to see what I'm looking right here. This was the sponsor, Delia Ramirez. These are co-sponsors. These are a lot of co-sponsors. This is a ton of co-sponsors. So this gives you an idea of how many people are standing behind the bill, along with Representative Ramirez. This is the legislative history. These are witness slips. This is where people can voice their opposition. These are the proponents. These are people who are joining in on it. And these are the opponents. You can see that there. So I will post that as well. And that's pretty much it for today. Again, this is in committee from what I understand right now. And we'll just have to see how far this gets. We will absolutely update you on this, because this is a very encompassing piece of legislation that's going to have a lot of implications, again, for associations, landlords, and lenders. So until next time, stay sane, and we'll see you soon.